go ahead and get started. Hello, everyone. Thanks for joining. My name is Aditya. Hope everyone is safe and healthy. We still are in the middle of a pandemic, so please follow CDC guidelines, and I wish you all good health. Today's coming to today's topic, it is the October 2020 visa bulletin, question and answers, documentation, and next steps. So this webinar is brought to you by sewa-aifw. It is a local nonprofit formed in 2004, and we have the executive director of SEWA, Raj Chaudhary ji, and we'll take a minute for her to talk about the organization.
Sure. Welcome, everyone. This is Raj Chaudhary, and I am the ED for SEWA, Asian Indian Family Wellness Program, that serves the underserved populations of South Asians, including the population of India, Pakistan, Bhutan, Nepal, Sri Lanka, Trinidad, Guyana, and the Caribbean diaspora, including Tibet. So we are here to serve our populations in areas that are most vulnerable, let's say women's issues, and the health initiative, senior program, and the youth program. So for more information, you can go on our website. But today, the reason why we are here is because the need in the community for immigration is playing havoc. So there has been several people that are needing immigration help. So we are here to answer some of the questions of the new law that has been in effect. So with further ado, I'm going to hand over the back to moderator. Thank you.
Thank you, Raji. So our speaker today is Satveer Chaudhary. He is an American politician and a former member of Minnesota State Senate and House of Representatives. He served from 1996 to 2010. So he's a member of the Minnesota Democratic Farmer Labor Party, and he was the first Asian American legislator in Minnesota history, and for a time, the highest ranking political official of South Asian descent and one of the youngest senator in the state. So he'll be talking about the October 2020 visa bulletin, and I'll hand it over to Satveer ji.
Thank you, Aditya. My name is Satveer Chaudhary, and very much appreciate SEWA inviting me to speak about the latest October Bulletin development. And I appreciate everyone's attendance here tonight. Since leaving the legislature in 2010, I've been practicing immigration law full-time, and gotten a lot of fulfillment out of my lifelong mission, which was whether it was in politics or the law, to help make people's lives better. The topic of today is today's webinar is the latest development in the October visa bulletin. If you don't mind, I have some prepared remarks, and so I'm going to read a little bit, but I think it's important because there are some details that need to be known, particularly the background. But then I'll also talk about some of my feelings on how to approach the new development, and that will answer a lot of questions that people have already on their mind or may have already asked. Just about everyone who is here tonight knows that Indian-born people have to wait longer for their green cards, in fact, much longer for their employment-based green cards than just about any other country in the world. The reason we have that is because the reason that is the case is because U.S. immigration law limits the annual percentage of green cards for each country. to no more than 7% of the total green cards given. So neither India or Belarus or Brazil or China or Canada, anyone coming from those countries, none of those can have more than 7% of the total number of green cards. Well, for most people immigrating to America from around the world, that's not a problem. But when you have a high population country such as India or China, but particularly India, and they are a big part of the employment-based immigration boom, IT workers, but others as well, they take up more than 7% in terms of raw numbers. So what do you do then? Well, you have to wait. And the way you wait, the waiting system has been set up is by the date by which you file your initial green card application. Back where you start with your labor certification and such. Once that's filed, the individual is given a date, and that date is called the priority date. So that's the date by which they have to start waiting in line. And unfortunately, with the different categories of employment-based immigration visas, many Indians have to wait a long, long time. In fact, many, many years. There are different immigration categories, employment-based immigration categories. The typical ones are EB1, EB2, EB3, EB meaning employment-based. Indian IT workers typically fall within the EB3 and the EB2 categories. And as you can imagine, EB1, those people who are qualified for those, they can move to the front of the line a little faster. And the people in EB2 categories, that's generally people who have master's degrees or higher and more experience in general. They can move to the head of the line a little faster. And then the EB3 people, those with your basic IT workers, bachelor's degree plus 6 years of experience, those people are they qualify for green cards, employment-based green cards, but they have to wait even longer within those categories. So at the moment, there is no permanent solution to this. The Congress has to pass a law to change that. So for the time being, we continue this. We expect this to continue to be the case. But at least temporarily, what has happened of recent is that the cutoff dates or the priority dates for EB3 have been advancing, and it has come to the point for just in the moment we are at now, coming up on in October, that they have actually moved ahead of those who are in the EB2 category. And I'll explain, why that's the case in a moment. So so then there's an added complexity for those who don't know that one little solution that was added for people having to wait a long time was that, before you become current, a couple of years before, will allow you to at least submit your application for your green card, and so it can get in processing, and then with that, the key part of that is that you could submit an application for an employment authorization document. And the reason that is attractive is because because there is no requirement, there's no employer requirement once you have an EAD. You can leave your current employer. Basically, you are free from your current employer to work anywhere you want on an EAD, and there's There's no no minimum wage requirement. There's no prevailing wage requirement. So it's really a free act of kind of freeing from the long, arduous road of employment-based immigration green card process for Indians to finally get one's EAD. That's what makes it attractive. Well, that is called the date for filing, where you can submit that application. So what it means is that for purposes of the adjustment of status, or your green card filing during the month of October, there are now thousands of EB2 applicants who could be able to take advantage of the downgrade of what is called a downgrade to EB3, to take advantage of filing for their green card by downgrading to an EB3. So I'll talk about that in a minute. At the moment, EB2 applicants with a priority date between May 15th of 2011 and January 1st of 2015 would be able to downgrade to EB3 and then file for their 485. So it's like the people who are at the head of the line, or who are farther ahead of the line, who have these particular priority dates, can downgrade their level of employment based and become eligible for this. I think a lot of people already understand this. A lot of people on this seminar are affected by this, but I do want to have some sort of explanation. It is complicated and convoluted, so if you're confused by my explanation, it is, you're in good company. It's confusing even for attorneys. Okay, so why is the EB3 advancing faster? Well, the 5 to 10 year historic average calculations indicate that EB2 India priority dates become current in about 10 to 11 years, while it takes 12 to 13 years for EB3 candidates to become current. And so this is a huge amount of time. And then as the result of the slow movement of EB3 India, historically over the last several years, many EB3 applicants have been able to have tried to upgrade their cases to EB2 because they may have since gotten a master's, or they may have gotten enough years of employment where they can be eligible and have an earlier priority date. But at the same time, new green card candidates who are eligible for EB2 have been insisting on having their applications processed under EB2. And sometimes that's possible. And then so the overall result is that there has been a higher demand for EB2 Indias. And there's, because of the migration from EB3 to EB2, especially for Indians. So the EB2 category has been advancing very slowly. And then the EB3 category, especially for Indians, has not seen the demand as a result, because it's just been this, you're just going to sit there for 12 to 13 years. So you might as well try and get a master's or try to get eligible for an EB2. So there's been less demand for EB3 India, and that's causing then EB3 to now advance more aggressively because there's fewer of them to use up the available visa numbers. And that is also because of the huge slowdown in general immigration in all categories. So there's simply been more available. embassies have closed. So embassies are not processing people from India. Therefore, there's a huge chunk of people who are not coming from India, and allowing more space for people who are who could very well be here in the U.S. to be able to adjust status from here. So there's a lower demand for EB3 in general, and then there's been a slowdown for of immigration in general, leaving more available slots. Okay, so this is not the first time we've seen this type of thing happen. And so we do have lessons that we can learn from. In 2018, there was a similar phenomenon with China, where the EB3 cutoff was advancing and ultimately became more favorable than EB2 for a period of time. And then so that allowed a lot of Chinese applicants to downgrade their petitions from EB2 to EB3, and then they were able to adjust status. At that time, and I think this applies now as well, it was important to note that it was a limited opportunity, because the EB3 was category that were, the advantageous EB3 category that we are seeing now will not last very long. Just as it did not last very long in 2018 with China, EB3 China, it's important to note that that it ultimately switched back, and the EB2 is now favorable once again, especially with China. What happened with the EB3 China was that the cutoff date under EB3 was more advanced than the EB2 for a while, until there was a sufficient number of applicants that to file or downgraded to EB3. And then that caused the EB2 and EB3 demand to balance out. And I'm pretty sure and I think my colleagues also tend to agree that that's what's going to happen here too. So what we're seeing is a limited window opportunity for people who have suddenly become current, or if they were to downgrade and become current, they need to act quickly. All right, so why should you consider downgrading? I mean, it is a downgrade after all. So what we learned from China was that that downgrading to EB3, and I will explain how to downgrade in just a few minutes. It would mainly result, it mainly results in your ability to file for your adjustment of status. That has a lot of benefits, including, as I said before, getting your independent work document, your EAD. It also allows for, it gives you a travel document as well, and that includes family members. And it also gives the ability to port your I-485 green card process to a new employer under AC-21 after 6 months. These are all little complex maneuvers, but it does allow for this. Ultimately, though, since the long-term wait time for EB3 is longer, for EB2, I think it's safe to expect that it will take ultimately longer to get the green card itself approved, unless there's some sort of future upgrade of the process to EB2. So, the point of the matter being that you're taking a bit of a risk. You can file your adjustment of status, yes. You could get your EAD, excellent. But that doesn't mean you're going to get your green card a lot sooner. it means that you're really just trying to get that EAD and your freedom to work in other places. Or perhaps you're on maybe you're on an H-1B, on an extended H-1B, and your circumstances have become precarious. An EAD would really be helpful, particularly for your family members. A spouse also then becomes eligible for an EAD. There's all sorts of benefits there, but you have to make sure to know that you won't necessarily get your green card sooner. There's also a big caution that as a lot of EB2 Indian applicants are downgrading, there will, as I said earlier, EB3 now will see more demand. It's like, and then that'll cause EB3 to slow down. And then EB2 becomes faster. So it's almost like, which exit do you take on a freeway? I mean, should you continue taking the side streets where you're slow and steady, or should you, now that an exit has opened up to a freeway, should you get onto the freeway, but then everyone else has the same idea, and then the freeway gets clogged up. So it's the same concept. And so so using the same analogy, it would be beneficial to those who get on the freeway quickly and react quickly. And I'll talk about that in a moment. So bottom line, the main reason and benefit for Indians to downgrade from EB2 to EB3 to be able to file their 485 adjustment of status, get their EAD for themselves and family members. So there's an advantage there. Approval of your 485 is a different story. A very limited number of applicants. The people who act fast, they're better organized. Perhaps they reside in an area where the 485 interviews are scheduled faster. Maybe you have a more advanced priority date. Those people could expect faster approvals and the actual green cards under EB3. So you really have to watch your situation too. Not everyone is going to get the green card, so to speak. But now those who downgrade, so on the same token, those who downgrade to EB3, you're going to have to, a lot of, depending on situation, you're going to have to wait longer for your actual green card compared to your EB2. So you have to consider whether this temporary benefit is really in your best interest. And that is going to be very, very situation specific. All right, so how does a downgrade work? Pay attention to this, because this is not as simple as one might think. And it's very tricky, and it's also very situation specific. So first of all, you don't necessarily have to go through the Perm process again. Most, if not all, Perm certifications that have been used in support of an EB2 can be used to support an EB3 petition by the same employer for the same position. Okay, so there's your individual nuance right there. Same employer, same petition. A lot of people have been in the queue a long time. They may have changed employers. They may have different positions. So that's got to be, so you have to watch that. So in that situation, the downgrade process involves, you submit a new I-140 petition, and you include the prior Perm labor certification. And of course, those who have gone through this know that the employer submits that on your behalf. So obviously, needless to say, there has to be employer buy-in for doing this. You can't submit it on your own. Okay, so now here's another quirk that you have to be mindful of. The USCIS does allow the use of a prior Perm labor certification, and it's probably expired by this point in most situations. They do allow the use of the prior Perm certification if it's been used in support of a prior I-140. During its initial 180-day validity term. So if you had a Perm and you never used an I-140, then you have and never submitted an I-140 within its validity term, then that's a problem. However, if you had an EB2, it's probably the case that it's okay. So this way, the same employer would be able to file a new I-140 petition under an EB3 category, relying on the previously used Perm certification without having to do a new Perm. Now, the question then comes up about premium processing. Should I premium process? Well, the answer is not necessarily. Normally, the USCIS doesn't allow premium processing if you have not filed, if you don't have the original blue paper Perm certification. Okay, so there's an issue there. Sometimes there's an exception. If a copy of the old of the Perm is filed with the same service center. Okay, so now if you're in the same service center, maybe you could get away with premium processing and not having the original. But if it's a different service center and you don't have your original Perm certification, the blue paper, quote unquote, then an attempt to premium process could be rejected. Okay, so all right, so what? I'll get to that in a moment. So when the new when the new EB3 I-140 is approved and the EB3 priority date is current, you can then file your 485 together with your EAD application and travel applications. Now, since the main goal of the EB3 downgrade is to be able to adjust status, and we don't know how long this advantageous cutoff date is going to last, in most cases, it's probably a good idea to file both I-140 and 485 concurrently. Okay, so let's get into some risks here. Now we're getting into real details. These are important details that people need to hear before they start getting into the weeds of it. Everyone thinks, well, I'm EB2, I'm in a downgrade, but not necessarily. What are the risks and downsides of downgrading? Okay, as I mentioned before, it requires the employer to submit another I-140 with the fees. And if you're filing concurrently, then the employer then is suddenly submitting an additional application. And there have also been instances where the newly downgraded EB3 priority date does not become current. And the applicant will ultimately be unable to file the 485 immediately after downgrade. So you have to avoid that risk. So filing concurrently is helpful, but you're going to need employer buy-in for that. Also, there has been inconsistent USCIS treatment of premium processing requests for I-140 petitions, where it is being asked where they are being asked to use previously submitted original Perm. And in some instances, they have rejected the entire I-140. So you got to be careful with, even though you want to move quickly, you say, okay, I'm happy to pay the premium processing to move quickly. Because of the inconsistency with using the original Perm or not, it may be a better idea not to do premium processing. If you have the original blue sheet, you should be golden, but you should still keep this in mind. To minimize the risk, you could just file the two concurrently, I-140, I-45 concurrently, regular processing. Once you get the receipt notices, then upgrade to premium processing. And then even then, employers an employer should be okay with that, because there is the rule that says if the employee is the requester of the premium processing, then the employee can pay for it. So that's another thing to consider. Going through an EB3 downgrade process, it does not automatically invalidate the prior EB2, so that's good news. So in the event that the EB3 downgrade is not successful, it's like your your EB3 I-140 is denied for some reason, or maybe it's withdrawn, the EB2 petition remains unaffected. Employers should also be very careful to analyze if there are any significant issues with the Perm at the time. Even at the time that it was originally filed, just double check. Maybe something was overlooked, even though it was approved. Maybe something has changed subsequently. You've got to double check that Perm. That means the wage, the position, everything. Specifically, make sure that the I-140 was properly filed and approved, and approved, of course. Of course, it has to be approved. The worst case result would be the USCIS finding out a reason to invalidate the prior EB2 I-140, and they can do that. Also, employers should be able to demonstrate ability to pay the Perm offered wage for the entire period going back to the priority date. For an EB3 downgrade, that means several years of tax returns, financials, pay records. Those will all have to be carefully analyzed and prepared. So what are the key factors to success for a downgrade? They are act early with a good priority date and downgrade analysis. You have to make sure the priority date has a chance to be current. And you must be amongst the first wave of downgraders. Two, you got to get your employer's support and commitment for prompt action. That means reviewing the Perm, reviewing the prior EB2, the I-140, the financial situation over prior years. Use an attorney who understands the process very well. And that includes navigating all the nuanced rules for Perm, you know, without aiming to offend anyone, unfortunately, there have been USCIS officers or even attorneys that are unaware of rules and procedures described, that I've described. And then finally, be flexible, be proactive, be ready to complete tasks quickly. You know, I can tell you from my experience, the biggest problem that I have with applications are the clients, and simply not providing documents, arguing, why do I have to provide this? Do I really have to provide that? My friends didn't have to do this. Why do I have to do that? And it all just leads to delay. So be very cooperative. So that is so for me, the upshot is be very careful about whether you want to choose this option or not. Even if you are successful in downgrading, there is a strong likelihood you're going to wait longer ultimately for your green card. How important is that EAD? Is right now, as opposed to getting your green card sooner? Think about that very carefully. Let's go through some of these questions. I just want to just make sure, I don't have the time to analyze people's individual situations. I appreciate people giving me their details, but I just don't have the time to analyze their situation, and I don't think it's a good idea either. I would undoubtedly have additional questions, but let's just go through these and I'll do my best. If we lose our EAD or advanced parole after downgrading, does that mean we lost the opportunity to go back to EB2? You haven't lost the opportunity, but you could very well need to go through the process again of a new I-140. Should we go ahead and do our medical now? No, we shouldn't. Medicals are only good for 60 days prior to submission, and then they're only good for 2 years, and you may not get your interview for 2 years. You may get your EAD, which is the kind of the point of all of this, but you may not get your interview, and you'd have to do your medical again. Someone asked about their priority date and what's their best course of action. I think you should have an individual consultation. Are the dates set for October bulletin? Will there be any chance anytime from now till end of October that the dates can go back? No. The dates are out for the October itself. Anything is up for grabs after that. Now I will have to, with this little caveat, the October bulletin came out. First of all, the October bulletin came out later than normal. And then when it came out, they made an adjustment the next day. It was to correct a mistake, but they did make an adjustment the following day, a clarification. But October is set for now. I have a feeling that November, maybe even December, will be similar, but those are only predictions. But it is a good question. October is set for now. Another question is documentation. I see that government issue ID. Does that mean U.S. government issue, or can we use Indian passport? Generally, that means that if you have an Indian passport, then that would suffice. I assume that's for the green card process. Due to COVID-19, my biometrics got canceled in March, and now I didn't hear anything from the USCIS. Can I shed some light on this? I think you can go ahead and give them a call. When there's a phone number on your biometrics, they're a lot better to respond than the other USCIS centers. They might, you're calling them might tickle them to send out another appointment date, but they are very behind. So I'm not surprised that had happened to you. I have my I-140 filed in EB3, but it's not approved yet. And my priority date is October 2013. Can I file for adjustment now? Or do I have to upgrade my I-140 to premium first? You do need, let's see. I'd need to double check on the October 2013. And do you have to upgrade your premium to, that's a good question. You know, you may want to just talk to your attorney on how they want to process that. You know, I could see, I mean, you already have a receipt notice. So, and if it is current, then you have then filing an I-45 could be possible. And so I would just want to find out first, you find out from your company's attorney how they want to handle that. But it is possible that you could file it is possible, I'm not suggesting that you do this, but there's possible you could simply file your 485 knowing that your I-140 is in process. For it to be cleaner, you may want to do premium so that you do have an approved I-140. But your attorney may have the opinion that since you have a receipt notice and you're current, that you could just get your I-45 in there as well, and that it would be considered concurrent. Let's see, I have an approved I-140 2014. This is kind of a specific one. I'd appreciate it if you could, you know, contact an attorney, have an individual consultation. A lot of individual questions. What happens if my green card final date is current, but due to a change in job, my perm is not filed by my new employer yet? That's very individual specific. Let's say my 485 has been approved under EB3. Can I file a green card later under EB2? You're in the EB3 category now, so so that's what you have an approved I-1. That's what your adjustment of status is for now. Now you would have to get back up to EB2 in order to do that. So there's there's some risks that you're taking there by jumping ship back to EB3. I'm going to avoid questions that talk about specific priority dates. My priority date is this, so therefore, am I going to get this? I want to stick to kind of more general policy questions. My son is 20 years old. Can I downgrade to EB3 and cover him? Yes, as long as he is hasn't turned 21 yet. So it's very much a timing issue. What happens to the EB2 backlog with everyone downgrading to EB3? As I mentioned in my talk, you know, it'll balance out. So with fewer EB2s, because people are jumping ship to EB3, then they will, so there's fewer people in that line, those dates will advance. And that's what we saw with China a couple of years ago. So this is it's very important to know that this is a temporary situation. Currently, I changed my employer, and my current employer is yet to file my perm prior to 2015. What will happen if my date becomes current? I mean, you know, you have to go through the process. you have to have an I-140. You have to have a perm. So if they are yet to file your perm, then I don't know how your priority date is 2015. Maybe that's but if your date becomes current, then a lot of these options could be possibly available to you, and you should consult your attorney. Can you work on any job with an EAD? Yes. One thing, but with employments, it's sort of. Any job, meaning any job, and this is what I advise people, any job that is same or similar to your current job. So, and the reason I say this is because I've had problems that it wasn't a just problem, but I had a problem with a client that came to me after he had been denied his citizenship, because even though he had an EAD, employment-based EAD, they accused him of not having a same or similar job after getting his green card. So even though there is a whole lot more flexibility, I just advise people to just make sure that your job is in a same or similar occupation, and the salary is commensurate. And if you're going to do anything outside of that, if you're going to jump up to a VP position and with big salary, consult an attorney first before you do that. Someone asked what to submit when no birth certificate is available. The instructions give alternatives, such as school leaving certificates, other health records. For Indians, it's important to note that the American system it holds fast to the rule that all births in India since 1972 were issued certificates. So if you were born, I can't remember if it's after 1972 or 72 and after, but since that time, if you were born since that time, you should have a birth certificate, and you will not be approved without one. Prior to 72, there's affidavits, school leaving certificates. Those are common ways to around a birth certificate. But even if you don't, it's the best thing is to get a birth certificate. You are far better off going through machinations to get a birth certificate than going through all these machinations trying to get around that. I know it can be a bureaucratic pain, but you should always go for the bureaucratic pain over problems with U.S. immigration. Is Form I-944 mandatory for all 485s? It's a good question. Yes and no. The official question, the official, let me just pull up the official instructions for I-944. And while I'm doing that, I will kind of explain what that is. The I-944 is a new form that started in February of this year after some litigation. That said, it was a new thing from the Trump administration to file what is called a Declaration of Self-Sufficiency. So, normally you have to, when you have green card applications, there's the ability you have to show your financial ability in some way. That's normally from the sponsor, and that used to be enough. But then the Trump administration says, no, we wanted to know that you are self-sufficient as well. So it's a big, long form that requires information about not just your sponsor's ability to pay in case you are not, but also your income, your savings, your real estate holdings, your debt, your credit score, whether you have health care or not. All of these things are now required under this form. But there are some exceptions on who can file the form and who cannot. And I'm just going to pull up the precise exceptions so that it's very clear, because there are some exceptions for employment-based. Well, I have to apologize. There may not be one. There may be an exception to some of the. I think what I'm thinking of is an exception to some of the income and asset requirements you need to disclose if you are in an employment-based application. But you still have to submit the form. So the answer to that question is yes, and it's an arduous form, and but I do recommend that it is filled out thoroughly. Next question is, if I downgrade to EB3 and do a concurrent filing, and the dates retrogress before the I-140 is approved, will I still get my EAD? Also, what happens if my new I-140 is denied? Would the older I-140 for EB2 still be valid? If your new downgrade I-140 is approved but the dates retrogress, will you still get your EAD? The answer is no. That was one of the things that I talked about, is that make sure that your date will be current before considering doing an EB3. So if you're really a long way out and there's a chance that it could retrogress to something different, you may want to rethink it. I mean, it could be worth a shot, but it depends on if your employer wants to spend the money. What happens if your new I-140 is denied? Is the older I-140 for EB2 still valid? The answer is yes. I think I mentioned that earlier. Let's see, in the chat section, I think people have some other questions too. I'm going to skip over some of the more specific ones of individual situations. My employer said I cannot downgrade my I-140 because it was signed by my previous employer and the company was bought by current employer later. I will need to leave current EB2 application as is and file a new Perm and I-140 to downgrade to EB3. Is this true? Possibly. Possibly. I think that it's just really specific to your situation, but possibly. I don't want to say for sure that it is. can my current EB2 priority date be retained when the new employer files a I-140 under EB3? It is retained because probably you're using an old Perm. So what your priority date is ported or retained via your old Perm. So it all depends on whether you can use the old Perm or not. Remember what I was saying about whether you have original Perm or a copy of your Perm, or you're filing the same service center. Some of those things could come into play, but your priority date is established by your Perm certification. So that's what travels with, as long as it's allowed to be under your as long as it is otherwise allowed to travel with the I-140, because again, you still need to analyze whether analyze income, you have to analyze the position and all of that. There may be a situation where you need to have new Perm because things are totally different. And in that case, the priority date could be different. But probably, how long does an audit request take for a Perm application? It's kind of off topic, but the quick answer is it can be many, many months. Is I-94 mandatory for everyone for employment base? Yes, plan on it. Another question about the doctor's appointment. I wouldn't do any doctor's appointments right now. Because remember, this is for your adjustment of status. This is a filing date. It's not a final approval date. And that could be many, many years. You won't necessarily be getting your green card soon. It's just that you'll be getting your EAD soon. So you really have to, people who are thinking about downgrade really need to think hard about how worth it is to have that EAD versus what will likely be a faster green card under your EB2. It may feel faster now, but that's just for those are just filing, your application filing date. It's not your final action date. And so you still may be better off in the long run sticking with EB2. When's the earliest I'm available for a consultation? I put all of my contact information at the top of the chat. Shoot me an email. I just changed jobs. My EB3 date is eligible. Can I apply for AOS using the previous employer's Perm and I-140? Yes, you can. You only, as long as your your current employer is going to want to, is going to need to include that supplement J, and that's the next question. Yes, I mean the green card it bears repeating that the I-140 and the green card application is to be approved for future employment. It's not necessarily to be approved with your current employer. So yes, your current employer would file the supplement J saying you do have a job offer, pending job offer, but that doesn't mean it has to be that employer. It could be another one down the road. So that as long as your I-140 is still valid, then you can file that. Your 485J must be included in part of the initial 485 filing. Yes, but if they don't, a lot of times you can wait for the RFE. There's a question there, can you wait for the RFE? Yes, you can, but just to make sure if your applications are not complete, then you risk rejection and delaying it. So says my current employer may not give before the end of October. Well, that's 4 weeks to sign a simple form. I wonder why that's the case. But in a vacuum, yes, you could possibly wait for the RFE. There's questions about acquiring different companies, very person specific, and that's got to be analyzed on an individual basis. If someone who has a perm and an I-140 approved, but they move to a new job and the position and salary has changed with the new employer, do they need to refile a perm? It depends on how much the position has changed and how much the salary has changed. It can be a same or similar position, and the salary can be commensurate, and it depends on commensurate based on location, as well as cost of living increases and inflation. So that requires some analysis. But if it's been a big change, it's maybe you need to refile the perm, but I wouldn't assume that you do. Do we need to attach pay stubs while downgrading or applying for AOS? You're going to have to show that, you have to ask yourself, what is the relevance to the pay stubs? Is it showing that you have had valid employment? That's not really an issue with adjustment of status. Are you trying to show your income for in order for your sponsorship of your family members? Are you including that as part of the I-944, your self-sufficiency? You always ask yourself, what do you need those things for? For pay stubs, probably. It's probably going to be necessary. But you want to know what you have to ask yourself specifically what they're for. You can look in the instructions, and sometimes pay stubs are necessary, sometimes they're not. In this situation, I would say more than likely yes, especially since you need to show, you have to have a declaration of self-sufficiency. Is this EAD, is the EAD will be good for kids age out? I'm not sure I don't understand the question, but if they're asking, can the kids get an EAD? The question is, if they are otherwise eligible for an EAD, they can apply for it under this process. So you just look in the rules, the instructions for the form. Another question about promotion. Does a promotion with same job duties require new perm? Probably not, but you need to double check that with your attorney and before you go for any downgrading. What if there's a mistake on the place of birth between the date of birth and passport certifications? Will an affidavit clarify this? Possibly. Why not just correct the passport? I mean, it should be done. And that's what I tell my clients to do. I mean, you're going to have to go through this time and time again in your immigration process. Why not just make the correction on your passport? I know it can be a pain sometimes with the Indian consulate, but I just think you really should be cleaning these things up rather than stressing out about these potential inconsistencies in information that can trip you up. But it might work. An affidavit might work. Can you apply for advanced parole while in India? No. You cannot apply for adjustment of status while in India. And you cannot leave the US until you have an approved advanced parole, not the approval notice, but the actual card in your hand. Otherwise, your adjustment of status will be deemed abandoned. So advanced parole, an advanced parole can be it actually can possibly be, I need to double check on that. Advanced parole in general, there are situations where the advanced parole can be sent to an address in India, but the general rule is that you have to have it approved before you leave the country. So I wouldn't do it any other way unless you have a special exception. Some of these questions I've already answered. Is going with a company attorney a must while filing an AOS? No. And then I guess the follow-up question would be, is going with any attorney a must while filing an adjustment of status? And you know, there's the technical answer, and that is no. You know, the system is set up so that you're not supposed to need an attorney. But if you go back to the initial assertion that I made that you know, in this, for downgrading, you need to act fast. You may want to get someone to do it for you who knows how to do it efficiently. Can we file an adjustment of status with an employer who filed for I-140 while working currently at a different employer? Well, I assume that the I-140 was not revoked and that you ported to a different employer legitimately. If that's the case, then yes, you have, and all other things are otherwise eligible, yes, you can. Another question about change in job responsibilities. Do you need a new perm? Some change in job responsibilities. Well, the term some or increase is a little loaded. You really have to analyze that with the job descriptions, and you should do that with your attorney and have that. If that is really an issue, then you should then there should be a detailed analysis. Let's go back to the Q&A question box now. When there's a change of employer, do we need to file a perm every time for a green card process? No. If your I-140 has been valid for 6 months, then that I-140 remains valid and it cannot be revoked. You can move to another employer as long as you're otherwise eligible to move to another employer, and you keep the old priority date. But just remember, when you become current, you do have to have a same or similar job offer and employment ready to go once the green card is approved, and that's what the I-45J supplement is for. It confirms at the last moment, just before your green card is approved, it confirms that you will be working, and that's what the green card is for. If I downgrade now to EB3 and get EAD now, later if the action dates for EB2 become current, will I be able to go back to EB2? Yes, you can go back to EB2, but you'll have to do you'll have to go through that process again. For some people, that's no big deal. All right, some of the questions are becoming a bit repetitive. What would be the priority dates movements for the next 6 months? That is completely unpredictable, but not entirely. As I mentioned before, in 2018, the same thing happened with China, and what happened a short time later is that things went back to the way they were. Let me ask the moderators at this point, because we are over an hour, are there any additional burning questions that you think should be answered with our time here.
Oh, thank you. Thank you for all the answers, Satveer. I think we covered a lot, and we understand it's specific questions cannot be answered here. This is a more general, high-level questionnaire, question and answer session. I think the only question I would ask here is the travel part. You know, once you have the applied for the adjustment of status, and then what happens to travel? Do we have to wait until the advanced parole actually comes to your hand? So which means you're pretty much stuck. Given COVID situation, a lot of people, families are back home, you know, emergencies happen. So what's a kind of suggestion at this point that you would give, you know, that's something people should think while applying for adjustment of status? How does it affect traveling out of country at this point?
I think you summarized it well, and I mean, you are stuck. Once you file your adjustment of status, you cannot. Well, you can leave the country. You're not prevented from leaving the country. But if you do leave the country, your adjustment of status application will be deemed abandoned. So when we say you have to stay, it means you have to stay until you get your advanced parole. If you don't want to abandon your application. Look, if it's a dire emergency and you don't have your advanced parole and you leave the country, the worst that's going to happen is that your adjustment of status will be deemed abandoned and you'll apply again when you return. Of course, for this whole downgrading process, it may be too late, but it's not fatal. It's not fatal to your immigration to abandon your adjustment of status. But that being said, you know, if you want to keep your adjustment of status pending, you do need to wait until your advanced parole card is in hand before you exit the country. That's just the rule. You are stuck if something comes up.
Yeah, thank you.
I suppose, I mean, if you look at it one way, if it is a true emergency, then then depart. Yeah. It's more important than your adjustment of status, which could be done later.
Yeah. Okay. Yeah, we're at 7:17, and I think respecting everybody's time, we're going to end the session here. Again, really appreciate Satveerji for all the time that you have taken to answer each individual question. I think we covered pretty much all questions, unless it is very specific to their case with all the personal information. But thank you again. Thank you, Seva, for organizing this. This is great for the community in Minneapolis, and people joining from elsewhere too. But being local to Minnesota, this work that you're doing is really commendable. Thank you.
I would also thank you very much, Aditya, for your being a moderator. Thank you to Dashrath and Juvi and Mubina, Raj Chaudhary, and of course Seva for providing this wonderful community service. I did leave my contact information in the chat box. I would very much appreciate people's feedback on my presentation, what you think could be, what you enjoyed and what you think could be improved. I'm always trying to improve what I do, and your feedback would be wonderful. If not, you can certainly also contact me via my Facebook page, Immigration Attorneys. I also have a blog called Immigration QA. Those are different ways you can contact and follow my activities. I'm also on Twitter at Chaudhary Law USA.